Hello everybody, I am Rangeen Pallav Tripathi. I am an assistant professor of law at National Law University, Odisha, and today I will be speaking to you about the social contract theories in the post-Renaissance phase. This is a module in the paper of advanced jurisprudence. Natural law is a concept of a higher validating order for the positive law made by men. That is, it propositions that positive law of men will not gain validity, will not gain legitimacy unless it conforms to a superior set of principles. Now, what exactly will be these superior set of principles? This nature and this identity of superior set of principles has acquired many shapes over the course of history. At some point of time, it was regarded as the law of nature. At some other point of time, it was regarded as the divine law. In the post-Renaissance phase of history, it was the social contract theory which acquired the shape of this higher validating order or the superior set of principles. Although traces of social contract theory can be traced back to the writings of Plato as well, it was only in the post-Renaissance phase that it evolved into a dominant political and legal ideology. The objectives of this course will be to identify the common features in most social contract theories, to comprehend the motivational context as to why the philosophers propositioned social contract theories, that will be Grotius, Thomas Hobbes, John Locke and Rousseau. To appreciate the social political context which has been conceptualized by these philosophers, to comprehend the implications of the social contract that they have enunciated, and to understand the state-citizen relationship contemplated by these philosophers. The module will start with a discussion on Grotius. However, the thrust of the social contract theories will be primarily covered by the writings of Thomas Hobbes, John Locke and Rousseau. Because Grotius, though mentioned about social contract theory in his writings, his main area of interest and his main area of thrust was international law. However, we will first look into the common features in most social contract theories. The social contract theories propositioned by different philosophers vary in detail. However, there are certain strands of commonality in all these social contract theories. The first is that all these social contract theories depict a state of nature. State of nature refers to a state of affairs which existed before men organized themselves into a society or law came into existence as an instrument of society. And there is also the assertion that the transition from a stateless society into a lawful society is marked by the instrument of social contract. It was through social contract that men organized themselves into a society and men organized themselves into a state. And one fundamental premise which is common to all social contract theories is that the authority of the government is dependent on the consent of the people. The government has authority not because God has willed him to do so. The government has authority not because it is natural for the government to have authority, but the government has authority because the people want the government to have authority. That is a fundamental premise on which all social contract theories are premised. And the last proposition, which is common to all the social contract theories, is that the relationship between the state and its subjects is governed by this social contract. What rights the state has over the subjects, what duties it has towards its subjects, what rights the subjects have towards the state. The entire gamut of relationship between the state on one hand and the subjects on the other hand is determined by this social contract through which the state is created and through which the law gains its validity. Starting with Grotius. Grotius conceptualized the concept of social contract not for establishing the order of liberty. His primary motive, his primary objective was to justify as to why people should obey the government. The incidents of his social contract are the following. He conceptualized social contract not as a postulate of reason, not something which is hypothetical, but as if it is something which actually happened in the history of mankind. He recognized that people of each country, of each society have a right to choose the form of government that they want. The choice can be different. Somebody can choose an autocratic society, somebody can choose a monarchy, some society can choose a democracy, but every society, every set of people have a right to choose the form of government under which they are supposed to be governed. And this right of choice is the basis of the constitution of a country. And once the choice was made, the people were bound under it. Once the choice has been made as to what form of government they want to be governed under, they had an absolute non-negotiable duty to obey the government. But if that government did not fulfill the terms under which it had come to power, if the government did not fulfill the objectives for which it was established, Grotius did not specify what will be the resolution. Did the people have an authority? Did the people have a right to resist the unauthorized acts of the government? Grotius was not clear. We have to understand that the main purpose of Grotius did not have to deal with concept of a state or the concept of a law. His main concern was international relations and international law. So he wanted stability in the domestic front of all the countries so that they can engage in international relations peacefully. That is why he used the idea of a social contract to ensure that people have an absolute obedience towards the government, which will mean that rebellion will be less, friction will be less, chaos will be less in each country, which will again provide the stability through which governments can engage with each other in an international scenario. Thomas Hobbes was the first clear proponent of social contract theory. To understand the philosophy of Hobbes, we first need to appreciate the times in which he lived. During the lifetime of Hobbes, who was a citizen of England, England was rife with civil war. There was a lot of violence, there was a lot of friction, there was a lot of rebellion going on in England. And Thomas Hobbes was impacted by it. So he developed his social contract theory to ensure that rebellion does not take place. He favored an absolute authority of the state to ensure that citizens or people do not resist the authority of the state, which may lead to a civil war. The philosophy of Thomas Hobbes is based on the state of nature depicted by him, and the state of nature of Thomas Hobbes is dependent on the human nature contemplated by him. According to Hobbes, human beings are primarily selfish, they are greed and they are aggressive. So in a state of nature where there was no state, when there was no government, when there were no laws, when each man is violent, when each man is greedy, when each man is selfish, it meant that there was constant friction in the society. The society was almost at all times at war. All the members of the society were against each other. This meant that basic requirements of life, like the right to live, was jeopardized. There was no prosperity. People were locked in fight with each other all the time. And this chaotic state of nature prompted the man. The man realized that they cannot live like this forever. They cannot continue to fight with each other and hope that they will survive for long. This tendency, this inclination to survive prompted man to organize himself into a state and into a government. So they surrendered all their rights to the sovereign. They surrendered all their rights to the government in exchange of self-preservation. Here Thomas Hobbes differs substantially from Grotius in the sense, Grotius recognized different kinds of social contract. There could be a social contract where individuals submit only half of their rights and do not submit the other half of their rights. There could be a social contract where individuals submit only some of their rights but do not surrender the other of their rights. But according to Thomas Hobbes, the only kind of social contract which was valid was when individuals surrendered the entirety of their rights, the totality of their rights to the sovereign, and in exchange the sovereign promised to preserve their lives, to protect their lives. However, as I have pointed out earlier, Thomas Hobbes wanted an absolute authority on the part of the state. Therefore, even though that was the promise of the state, the subjects cannot demand the fulfillment of any obligations by the ruler. The subjects could not demand, could not throw away the government by saying that it is not preserving their lives. They did not have the right to resist. And this sovereign which was created was not subject to any higher order, any superior principle, any divine law, any natural law. Natural law was recognized by Thomas Hobbes primarily as a set of moral guidelines. It was not enforceable, it did not have sanctions, and if the state did not conform to these principles, then there was no problem. The validity of the laws promulgated by the state did not depend on them conforming to any higher set of principles. And he justified the authority of the state because of the common purpose for which the state was established. The state was established to ensure that people survive, self-preservation, and that is why whatever that the state did was legitimate and valid. Hobbes, as you have seen, did not proclaim some natural rights for men. The state which he created by social contract was despotic, it was absolute, its authority was non-negotiable. The individuals did not have the right to object to the authority of the state. So, it is not any higher set of principles that the individuals are being entitled to under the social contract of Hobbes. However, his conceptualization of human nature and his claim that however existential the right might be, every man has a claim against another man. Every individual has an expectation from another individual. That laid the foundation of subsequent development of inalienable rights for the individual. He made individual the center of his political universe. In his zealousness, he vested the state with too much of authority, with too much of power, but we do need to remember that all this power, all this authority was vested at the end to protect the individual. The end, the purpose was the preservation of the life of the individual. However, there are substantial criticisms directed against Thomas Hobbes due to the totalitarian regime of the state. The state was absolute power holder. There could be no objection, there could be no dissent against the power of the state. And the principles of natural law were relegated to the background, which meant that the authority of the state became unrestricted. There was no higher set of principles that it had to adhere to. Individual had no right to resist the despotism of the state. And the most important factor is that the state had so much of power, the state had so much of authority. However, the objective of the state was minimal, only the preservation of the life of the people. It did not have to aspire to some higher principle, it did not have to aspire to a superior goal, it did not have to live up to a more great ideal. So, in comparison and balance, the individual surrendered too much to gain too less. After Thomas Hobbes, it was John Locke who revolutionized the idea of social contract, and his philosophy had significant impact on subsequent political ideology. In the writings of Locke, social contract and natural law acquired the similar stature which they enjoyed in the medieval era and in the earlier conceptions of natural law. That is, unless the positive law of men is conforming to the natural law, conforming to a higher order, it will not gain validity. And unlike Thomas Hobbes, Locke used the idea of social contract to limit the power of the government, to establish restrictions on the authority of the government. Hobbes used the same concept of social contract to justify an unquestionable authority of the state, whereas Locke used the same concept of social contract to justify inalienable rights of the individual, to justify that the state cannot have absolute authority. The state of nature depicted by John Locke is also substantially different from Thomas Hobbes. In the state of nature depicted by Locke, there is peace, there is goodwill, there is cooperation, and there is substance. Man is endowed with the faculty of reason, and he interprets the law of nature through that faculty of reason. And every man has the right to live according to his own rights, as long as the man is not harming others. And every man has a right to interpret the law of nature and defend himself against any transgression committed by another individual, and also to punish or sanction another individual who is transgressing the law of nature. And this right to enforce the law of nature created the need of a social contract, because if man was peaceful, if everything was fine, why organize yourself into a state? Why create laws? Because when every man was entitled to interpret the law of nature, there was a multitude of interpretations. When every man was entitled to enforce the law of nature and impose sanctions against other individuals, there was chaos, because there was no certainty as to what exactly is my right under the law of nature. If I said, according to the law of nature, I am entitled to 10 coins, somebody else would say, according to the law of nature, I am entitled to only 2 coins. This multitude of interpretations and every individual being entitled to enforce the law of nature meant that there was great amount of uncertainty about the preservation of the rights which every individual had in the law of nature. Therefore, the social contract was created. And in this social contract, man retained all his rights, and more importantly, man retained his inalienable rights of life, liberty and estate. The rights which he surrendered to the state were twofold. First, the power to interpret the law of nature for his own preservation, and second, the power to enforce the law of nature by punishing transgressors. These were the only 2 rights which were surrendered to the state to ensure that there is uniformity as to what is the law of nature in a society. There is uniformity of interpretation, and also there is a centralized singular authority which will punish transgressions, because if every man takes it upon himself to punish others for violations of the law of nature, it means that there will be no uniformity, it means that there will be subjectivity, which is not good for an ordered society. The philosophy of John Locke had significant contribution in shaping the political ideology of subsequent centuries. In the eyes of Locke, the state became a purposive enterprise. It was established for a purpose, and it derived its validity from that purpose alone. If it did not fulfill that purpose, then the whole edifice of its existence was questionable. And he viewed the power of the state as a power in trust. State became a trustee of the power given to the state by the people for a particular purpose. And the state did not have unchallenged authority. The state was answerable at some level because the people had given power to the state for a certain purpose, and if the state did not keep up to that purpose, then its legitimacy was questionable. However, there also has been substantial criticism against Locke, primarily due to the incompatibility in his theory in relation to 2 things. On one hand, he proclaimed the inalienable rights of the individual. On the other hand, he proclaimed that the society is governed by the majority will. That is, if the majority of the society is in favor of something, that should be implemented. He did not provide a solution as to what will happen if the majority will is against the inalienable rights of the individual. And though he recognized the right of the individual to object to the unauthorized acts of the state, he diluted the right of resistance. According to him, the right of resistance could be exercised only in extreme situations, only when there is a sufficient pattern of abuse of the power by the state. In individual incidents where the state overreached its authority, where the state violated its purpose, Locke did not recognize the power to object to the authority of the state. Unlike Thomas Hobbes and Locke, whose political philosophies were at some level consistent, Rousseau's theory is filled with complexity, and because of its complexity, it has been cited in favor of competing ideologies, in favor of contrasting ideologies. At times, Rousseau has been explained as a champion of democracy. At times, he has also been described somebody who favors despotism, because throughout his political theory we see a common strand, that is, he tried to balance the natural right of man and the supremacy of the community, and in this balancing he has been interpreted in both ways. The state of nature depicted by Rousseau is similar to the one proclaimed by Locke. Man, according to Rousseau, is not inherently evil, is not inherently malicious the way Hobbes conceptualized human nature to be. And the state of nature was not one of warfare, was not one of friction, but which was one of primarily individual isolation, which means that each man was onto himself. Each man minded his own business, lived his own life. There was no community living in a stateless society. Now this peaceful state of nature, now this joyful state of nature was disturbed by the idea of private property. According to Rousseau, the concept of private property introduced elements of jealousy and greed in the conduct of man, which disturbed the peace which was there in the society. And this loss of equanimity required that a social contract be formed and a state be created, so that man can live under a common rule and can enjoy peace. The social contract conceptualized by Rousseau was oriented to ensure that the natural rights of freedom and equality of each man is protected. Man did so by surrendering all his rights to the community, and in exchange the community guaranteed the natural rights of man by converting them into civil rights. It was the responsibility of the community to ensure that in exchange of submission of all the natural rights which the man might have enjoyed under the law of nature are protected in the form of civil rights under the state. The government was obligated not to respond to individual interest, but to collective interest of the community. The sovereign conceptualized by Rousseau was not an individual, was not a singular institution to whom all powers was delegated. The sovereign conceptualized by Rousseau was the general will of the community. The individual was to be governed by the general will of the community, and this general will comprised of the collection, the collaboration of all the individual wills of each person. And according to Rousseau, because of that, this general will can never run counter to individual will, because each individual forms the general will. So general will can never be antithetical to the individual interest of each individual. There could be no conflict between the interest of the individual and the interest of the community, because individuals themselves are a part of the community. They have created the community, and transferring authority to this community ensures that individual interest of each person is protected. Rousseau gave great vigor to the idea of democracy. He never favored representative democracy of the modern era, the way we see it today. He did not favor a indirect democracy where representatives are elected and they decide the matters of the people. According to him, general will found its greatest expression in a system of direct democracy where people got together to settle matters for themselves. And he also gave us the idea of protecting the individual interest through the community interest. He did not see the community and the individual as competing ideologies. For him, the protection of one meant the protection of the other. There was no clash of the interest between the individual and the community. However, the major problem with the theory of Rousseau is the contrasting ideals which he tries to uphold at the same time. He wants every man to enjoy unrestricted freedom and equality, and at the same time he also wants the community to reign supreme. What will happen if the community is not in favor of protecting the freedom of the individual, is not in favor of protecting the equality for the individual. There is also a problem about his insufficient explanation of the general will. What was general will? How do you identify the general will of the persons? Is it simply majority will? Is it simply the right will? Though he elaborated on the matter, it left a lot to be desired as a practical doctrine, because it was difficult to identify for sure what exactly represented the general will of the community. And also the fact that his theory is more suitable to small city states where the population is smaller, where people can actually exercise the form of direct democracy, which is inconceivable today with the size of the country and the quantum of the population that we have. And his theory also had trappings of despotism, because he identified the community will to be supreme. There could be no objection, there could be no resistance to what the general will dictated, even though at times it might run counter to the individual interest. When we summarize, we can see that the generally social contract theories are directed to underline that the state derives its authority, derives its validity from the consent of the people. What authority the state has, what authority it does not have, that might differ according to the conceptualization of different people. However, the fact that the state is not entitled to rule its people because of a will of God, because the nature dictates so, but because people themselves have decided for it to happen. The social contracts conceptualized by different philosophers vary in terms of their background, varies in terms of their context, varies also in terms of their implications. Rousseau, for example, recognized the right of people to choose whatever form of government that they wanted to be ruled under. But he did not accommodate that once that choice has been made, people could resist. According to him, once you have made the choice as to the government which will govern, you cannot back down from that choice. You cannot backtrack from that choice. The choice is binding. On the other hand, Thomas Hobbes also recognized that people got into a social contract to create a state and its authority. But according to him, there could not be different kinds of social contract. There could not be different kinds of government. The only government which was valid was one where state was given all the rights by the individual. All rights, all liberties were surrendered, and in exchange state granted the protection of life to the individual. It could not happen in the eyes of Thomas Hobbes that individuals would surrender only some of their rights or many of their rights. The totality of the rights had to be surrendered. On the other hand, Locke recognized that only two rights need to be surrendered for the creation of the state: the right to interpret the law of nature and the right to enforce the law of nature. Otherwise, the state was only a purposive mechanism to ensure that the life, liberty and estate of the individual is protected. Rousseau, on the other hand, recognized the community in the form of the general will as a supreme authority. He talked about direct democracy, and he talked about the fact that the general will of the community will take care of the individual rights of the people. In conclusion, we can see that social contract theory developed in many shapes, in many forms. However, the most significant contribution of the social contract theory was to humanize the idea of state, from the abstraction of law of nature to the religious divine law. We understood that state is the creation of human mind. State is the creation of human endeavor. State is created by human beings and, more importantly, for the human beings. And the authority of the state is dependent on what the people wanted and not what the government thought the people wanted. Thank you.